Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Have you heard that Louisiana just passed a new law that requires the Ten Commandments to be posted in public school classrooms? I'm excited to tell you about this because I'm passionate about the law and gospel. I like to talk about the law and my Christian faith. This is Talk Law Radio. I'm Todd Marquardt. Now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. Podcasts, Facebook, YouTube, and talklawradio.com. Louisiana Bill 71, House Bill 71, was enacted to put the Ten Commandments in classrooms. It says the legislature finds and declares all of the following. In 2005, the Supreme Court of the United States recognized that it is permissible to display the Ten Commandments on government property. That was in the case of Van Orden versus Perry, United States Supreme Court, 2005. In 2006, the legislature enacted Act number 602 of the 2006 regular session of the legislature, which provided for the Secretary of State to publish the Ten Commandments and other historically significant documents for posting in courthouses and other public buildings to address a need to educate and inform the public as to the history and background of American and Louisiana law. In 2019, the Supreme Court of the United States further recognized that the Ten Commandments have historical significance as one of the foundations of our legal system. That was in the case of American Legion versus American Humanists Association, 2019. The court also ruled that the displaying of the Ten Commandments on public property may have multiple purposes, such as historical significance and represent a common cultural heritage. Recognizing the historical role of the Ten Commandments accords with our nation's history and faithfully reflects the understanding of the founders of our nation with respect to the necessity of civic morality to a functional self-government. History records that James Madison, the fourth president of the United States of America, stated, "We have staked the whole future on our new nation, upon the capacity of each of ourselves to govern ourselves according to the moral principles of the Ten Commandments." Including the Ten Commandments in the education of our children as part of our state and national history, culture, and tradition. This is all in the new law that Louisiana passed that puts the Ten Commandments in public classrooms across the state. So then, along with the Ten Commandments, this law also allows the Mayflower Compact of year 1620 to also be posted at the school's option, and possibly the Northwest Ordinance of 1787. The law goes on further to say it is the legislature's intent to apply the decisions set forth by the Supreme Court of the United States in Van Orden versus Perry to continue the rich tradition and ensure that the students in our public schools may understand and appreciate the foundational documents of our state and national government. The Supreme Court of the United States acknowledged that the Ten Commandments may be displayed on local government property when a private donation is made for the purpose of the historical monument. That was in the case of Pleasant Grove City, Utah versus Suman. That was in 2006. It is the intention of the Louisiana legislature that this section shall not create an unfunded mandate on any public school governing authority. School boards are encouraged to use documents that are printed and made available to the schools free of charge. The text of the Ten Commandments shall read as follows. The Ten Commandments. I am the Lord thy God. Thou shalt have no other gods before me. Thou shalt not make to thyself any graven images. Thou shalt not take the name of the Lord thy God in vain. Remember the Sabbath day to keep it holy. Honor thy father and thy mother, that thy days may be long upon the land which the Lord thy God giveth thee. Thou shalt not kill. Thou shalt not commit adultery. Thou shalt not steal. Thou shalt not bear false witness against thy neighbor. Thou shalt not covet thy neighbor's house. Thou shalt not covet thy neighbor's wife, nor his manservant, nor his maidservant, nor his cattle, nor anything that is thy neighbor's. And then with the Ten Commandments, there's a history that can be posted as well. So this is going to be challenged probably, and there are some Supreme Court cases that I want to go over with you. The first one is Kennedy versus Bremerton School District. This was a case about a football coach that wanted to pray after the football game with whatever students wanted to join him. It was voluntary. Well, the Bremerton School District told him to stop praying with the students because they said it violated the Establishment Clause of the First Amendment of the United States Constitution. So let me go to that Establishment Clause so that we can be reminded what it is about. The First Amendment's Establishment Clause prohibits the government from making any law respecting an establishment of religion. This clause not only forbids the government from establishing an official religion, but also prohibits government actions that unduly favor one religion over another. So the school board did not want to be sued because they were somehow favoring religion. Well, the football coach, Joseph Kennedy, sued the school district because they actually fired him for violating his rights under the First Amendment and Title VII of the Civil Rights Act of 1964. The district court held that because the school district suspended him solely because of the risk of constitutional liability associated with his religious conduct, its actions were justified. So the coach appealed, and the U.S. Court of Appeals for the Ninth Circuit affirmed that district decision. And so he appealed again to the United States Supreme Court, and the court found that the issue was whether a public school employee's prayer during school sports activities was protected speech, and if so, can the public school employer prohibit it to avoid violating the Establishment Clause. So there were two issues, really, whether it was protected speech and whether it was violating the Establishment Clause. So let's look at the right to free speech clause that is at issue. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, of abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So that's the free speech clause. And the court held that it was wrong for the school district to fire him on that basis. The coach won. The free exercise and free speech clauses of the First Amendment protected his right to engage in a personal religious observance, and he couldn't be reprimanded for that. The court said the Constitution neither mandates nor permits the government to suppress such religious expression. And the reasons that they said that was because the coach wasn't forcing the students to pray with him. They wanted to pray. And so the court said, no doubt coercion was among the foremost hallmarks of religious establishments the framers sought to prohibit when they adopted the First Amendment. Members of the Supreme Court have sometimes disagreed on what exactly qualifies as impermissible coercion in light of the original meaning of the Establishment Clause. In this case, the coach's private religious exercise did not come close to crossing any line one might imagine separating protected private expression from impermissible government coercion. The district court's own description of the facts never suggested that the coach was coercing the students to pray. The district conceded in a public 2015 document that there was no evidence that students were directly coerced to pray with the coach. Mr. Kennedy repeatedly stated he never coerced, required, or asked any student to pray, and that he never told any student that it was important that they participate in any religious activity. So the reason that this case is important is because it changed the way the Supreme Court evaluated the Establishment Clause. There was a previous statute in Kentucky that required public schools to post the Ten Commandments. And I'm trying to find that here. Don't see it. Well, anyway, there was a court case. Oh, here's the Kentucky law. The Ten Commandments to be displayed. This was a 1978 law. Shall be the duty of the superintendent of public instruction, provided sufficient funds are available as provided in subsection 3, to ensure that a durable, permanent copy of the Ten Commandments shall be displayed on a wall in each public elementary and secondary school classroom in the Commonwealth of Kentucky. But then there was a court challenge to it in Stone versus Graham, which went up to the Supreme Court in 1980. And the court ruled that the Kentucky law violated a test established in another court case, Lemon versus Kurtzman, and thus violated the Establishment Clause. So let's look at Lemon versus Kurtzman. This was a case about two states that had a law that got challenged. The Pennsylvania statute was passed in 1968. It provided for funding for non-public elementary and secondary school teachers, salaries, textbooks, and instructional materials for secular subjects. So a non-public school could have been a religious school, a parochial school, and it provided for funding to a religious school. So that's why it was being challenged then. Rhode Island had a statute that was passed in 1969 that provided state financial support for non-public elementary schools in the form of supplementing 15% of teachers' annual salaries. And because it went to non-public schools, some of them might have been religious schools, and so that's why it was being challenged in the court. And the issue was, do statutes that provide state funding for non-public, non-secular schools violate the Establishment Clause of the First Amendment? The court held that a statute must pass a three-pronged test in order to avoid violating the Establishment Clause. Number one, statute must have a secular legislative purpose. Number two, its principal or primary effect must be one that neither promotes nor inhibits religion. Number three, it must not foster excessive government entanglement with religion. In this case, the court held that both the state statutes in question had secular legislative purposes because they reflected the desire of the states to ensure minimum secular education requirements were being met in non-public schools. The court did not reach a holding regarding the second prong, which was principal or primary effect must be one that neither promotes nor inhibits religion. But on the third prong, it found the statutes constituted an excessive government entanglement with religion. This is the court case that was overturned by Kennedy versus Bremert. So the test after the Kennedy versus Bremert is consideration of historical practices and understandings. So going back to the facts in the Bremert case, where the coach was praying on his own and students just happened to be praying with him without him asking. Applying that test, there is no conflict between the constitutional commands of the First Amendment in this case. So Louisiana felt like, since the test had changed, the standard for whether a law violated the Establishment Clause changed, that it could pass this new law requiring the Ten Commandments to be posted in public school classrooms. Last year, Texas attempted the same thing. In Senate Bill 1515, it was going to amend the Education Code by adding Section 1.0041 to read, Display of Ten Commandments. A public elementary or secondary school shall display in a conspicuous place in each classroom of the school a durable poster or framed copy of the Ten Commandments that meets the requirements of subsection B, which are, it must include the text of the Ten Commandments as provided in subsection C in a size and typeface that is legible to a person with average vision from anywhere in the classroom in which the poster or framed copy is displayed, and it must be at least 16 inches wide and 20 inches tall. And these are similar text of the Ten Commandments. I brought my Bible with me, the Holy Bible, God Bless the USA Bible. It's a King James version, and so I'm not reading from it, but I did bring it. The problem with this Texas statute is that it was in committee too long, and there was no vote on the House floor by the deadline. And Dan Patrick tweeted on X, he posted a comment on X about this. He said, Dan Patrick is the lieutenant governor. He said, Texas would have been and should have been the first state in the nation to put the Ten Commandments back in our schools. Last session, the Texas Senate passed Senate Bill 1515 by Senator Phil King on April 20th and sent it over to the House to do what Louisiana just did. Every Texas Republican House member would have voted for it, but Speaker Dade Phelan killed the bill by letting it languish in committee for a month, assuring it would never have time for a vote on the floor. This was unexcusable and unacceptable. Putting the Ten Commandments back in our schools was obviously not a priority for Dade Phelan. So he vowed in this tweet to get somebody to sponsor this bill once again when the legislature's back in session. The Ten Commandments comes from the book of Exodus in the Christian and Jewish Bible, chapter 20, verses 3, 7, 8, and 12 through 17. Now, you're probably wondering about the separation of church and state. That comes from something that Thomas Jefferson said. He wrote a letter in 1802 to the Danbury, Connecticut Baptist Convention. and I have a copy of it here. I'm going to read it to you. Gentlemen, the affectionate sentiments of esteem and approbation which you are so good as to express towards me on behalf of the Danbury Baptist Association give me the highest satisfaction. My duties dictate a faithful and zealous pursuit of the interests of my constituents, and in proportion as they are persuaded of my fidelity to those duties, the discharge of them becomes more and more pleasing. Believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legitimate powers of government reach actions only and not opinions, I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. He added that phrase. It wasn't in the Bill of Rights. It wasn't in the First Amendment. That phrase, thus building a wall of separation between church and state. He added that. So I found a Stanford professor and director of constitutional law who said, the phrase separation of church and state appears nowhere in the Constitution, and the founding fathers saw nothing wrong with having religion in American culture. While Congress is prohibited from enacting a state religion, the founding document says nothing about banishing religion from the public square. The words separation of church and state are not in the Constitution. I think this is a shorthand version of what the Establishment Clause means. The passage in the Constitution reads, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. It does have a deep history because there were, in the 18th century, prominent writers who openly advocated for a union between church and state. There's actually a famous essay by one of the bishops in the Church of England. And our framers did not believe in a union between church and state. Instead, they wanted to protect against government control of religion, and that they did not object to symbols of faith being present in the public square. It did not mean that they believed the American people should be any less religious than they chose to be. It didn't mean that the culture, that there was anything wrong with having religious elements in the culture. What it meant is that we would not have a system in which the government was able to tell us what to believe, was able to control churches, decide what their doctrines, decide who their personnel would be, and so forth. So there you have it. Separation of church and state was something that Thomas Jefferson said, but it's not any part of the law. And so going back to the Kennedy versus Bremer decision, we know that because of the new evaluation of these types of laws is going to be evaluated based on historical practices and understandings. So I think that's why the Louisiana law also included those other documents, the Mayflower Compact of 1620 and the Northwest Ordinance of 1787. But let me know what you think. You can post a comment on Facebook or on YouTube or on X, formerly known as Twitter. Let me know what you think about whether the Ten Commandments should be in schools or should not be in schools. Do you think it's a good idea or a bad idea? You can also email me at host@talklawradio.com. That's HOST@talklawradio.com. Thank you for listening to my program today about the Ten Commandments in public schools. Please visit YouTube, search for Talk Law Radio, look for the Lady Liberty and the red, white, and blue logo, and click subscribe. If I get 1,000 subscribers, YouTube will let me stream live just like we do on Facebook. I enjoyed talking to you today, and I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.